Please rise. Justice of the Appellate Division, Supreme Court, First Department. We hear all persons having business with the Appellate Division. Draw near, keep your attendance, and you shall be heard. Please be seated.
Good afternoon, and welcome to the Appellate Division, First Department. You, ladies and gentlemen, know the rules of the road here. I will be calling the calendar. Please know that the panel is fully familiar with your briefs and the record, so please ask for the time that you need, not the time that you want, so that I don't have to do it for you. Also, you notice that there are only 4 judges physically present on the bench. Today, our panel is fully complemented. One of our members, Justice Moulton, will be listening virtually and will be participating post-argument in our conference. Okay? All right. People versus Robert Fekou. 4 and 1 and 4. Winters versus Atlantic Development. Okay, respondent? How much time do you want? None. The case is submitted, and thank you, ma'am. Tatiana versus Mark R. are submitted. Park v. Kim. Appellant? Seems you've scared them away. Do you still want time to argue? Thank you, submitted. Marunick versus Ray Realty. Okay. 4 and 2 and 5. Marunick versus Ray Realty. Park Kim was the first case I called. Park versus Kim. Okay, I'm sorry. Somehow you submitted. Okay, my apologies. So again, let's do this one more time. Marunick versus Ray Realty. Okay, 5 and 2 and 5 and 2. Okay? Dulce Mascolo, and I know I messed up that name and I apologize, versus 701 7th Property. Okay? 5 and 3 and 5. People versus Luis Rodriguez is submit. Nostalgic Partners versus New York Yankees. Okay, I'm going to do 6 and 2 and 6, and understand that if my colleagues have more questions, we will go beyond that timeline, so do not fret, okay? All right, Tri-City Valley Cats versus Houston Astros. 6 and 2 and 6, same thing goes for you, gentlemen. People versus Ron Hill. Submitted. Casino Towing versus New York City Department of Consumer. 5 and 1 and 5. IS Christie Management versus ADP. Okay. Okay. 5 and 2, 5 and 2. People versus Jermaine Trailer.
Justin Bonus on behalf of Mr. Trailer, requesting 8 and 2.
5 and 1 and 5. Fenton versus Hannah. 5 and 1, 3 and 3. Mendez versus City of New York. You're ready to submit? Thank you, sir. Case is submitted. Gottwald versus Garagos is submitted. Amato versus Verizon New York submitted on both appeals. First case on the calendar, People versus Robert Fecco. You may proceed.
Good afternoon. Allison Kale on behalf of the defendant appellant, Mr. Robert Fecco. The court's numerous comments about Mr. Fecco and his self-representation made in front of and sometimes specifically directed at the jury violated Mr. Fecco's constitutional rights, both to a fair trial and his right to counsel.
Was the judge supposed to allow the defendant to continue to violate instructions of the court without commentary?
The commentary here went far beyond just correcting anything that was allegedly happening that was disruptive in the courtroom. The court called Mr. Fecco misleading, difficult, insulting, the cause of all delay, also insinuated that he made an irrational decision by exercising his constitutional right to represent himself. The court said, "Oh my God, everything we said when the jury was out of the room seems to have gone nowhere," threatened, "If I took control of my courtroom, you wouldn't be here." The court lamented the fact that Mr. Fecco didn't have an attorney, and when he tried to explain that, the court said none of the 4 attorneys were good enough for him, a comment that the court itself apologized for, but did not strike and did not issue any curative instructions.
How do you reconcile your claim that the jury was prejudiced against the defendant by the judge's comments and the fact that they acquitted defendant of 9 of the 10 counts?
So while
It seems
Mr.
to me
Fecco
very
was
unlikely that they would have acquitted him of 9 of 10 counts if they were so prejudiced against him.
he was ultimately convicted of contempt, and the problem here is that all of the court's comments portrayed Mr. Fecco in a contemptuous manner. Even the DA characterizes it as contemptuous behavior, and that's what the court was telling the jury, was he was guilty of contempt. He can't even sit in this courtroom and do anything. I'm going to tell you that he's insulting me, he's disrespecting me.
All of that was obvious from the record, counsel. All of that, everything you're complaining of, was painfully obvious from the record.
Mr. Fecco's conduct here, this court has been very clear, even if in most cases it's defense counsel, even if they are prodding that or causing something, the court cannot come back with these insulting comments in front of the jury. The problem here is that this happened repeatedly in front of the jury, from the beginning of jury selection through the revocation of Mr. Fecco's right to proceed pro se.
As was your client's disrespect and complete disregard of court instructions throughout the entire proceedings. Quite frankly, I think the judge showed a tremendous amount of restraint in light of the outrageous behavior of your client.
Mr. Fecco's conduct here, even if characterized by this court as outrageous, does not justify what the court did in response, which was denigrate him in front of the jury. The Seventh Circuit in El Bay had a very similar case, and they recognized the purpose of the comments doesn't erase the bias that happens because of it, and that can't erase the bias that happened here. And
I was struck in the record that it seemed to me that the judge also admonished the prosecutor more than once and fairly sharply. Do you think that had any balancing effect?
No, it has no balancing effect here, where that was once in a context of her objecting to something that Mr. Fecco was doing and trying to preserve that record. That's the only instance that I'm aware of happening in this record, where again, it's a months-long trial, and these comments are happening by the court from the very beginning of the trial, from jury selection through when the court ultimately revokes Mr. Fecco's right to proceed pro se.
The fact that this simple case took a month to try speaks volumes, but you'll have time on rebuttal.
Good afternoon, Christopher Peterson for the Office of the Bronx District Attorney. Here, the jury's verdict shows that the defendant was not prejudiced by the comments that the judge made in front of the jury.
Is that a standard that we should be considering? And although the jury acquitted on the lion's share of the counts, that doesn't necessarily equate a balance, does it?
No, that's correct, Your Honor, but I think that all of the comments made by the judge have to be viewed in context. And although at times they were ill-tempered or impolite, that it was proper that the defendant was admonished and that this should be viewed against the backdrop of his obstreperous behavior and the fact that he constantly disregarded the court's instructions and disrupted the trial.
Out of a 30-day trial, as your adversary has pointed out, how many of those days would you say the defendant engaged in this type of disruptive behavior in front of the jury?
On each day that the defendant was present in court, he engaged in disruptive behavior, and in each day during voir dire, he engaged in disruptive behavior.
How far were you into the trial before the court finally imposed replaced him as pro se with his counsel?
It was several days, it was many days into the trial, if not weeks, and the defendant was warned repeatedly that he could be removed from the courtroom, and in fact would be removed from the courtroom if he continued. And he was offered numerous opportunities to correct his behavior and didn't.
And I believe that the verdict here was rendered even after the defendant's examination was struck in light of his refusal to allow cross-examination of himself.
That's correct, Your Honor.
Okay.
Thank you.
Thank you.
Just very quickly, this isn't a simple case. It was first-degree rape charges that he faced, in addition to first-degree second abuse charges related to 2 incidents. That's why a trial took a month long here. And in Leggett, this is a case where this court reversed. There were also acquittal of charges there, and there's acquittal of charges here, and reversal is similarly required. And the conduct being characterized by this court as disruptive, it's Mr. Fekou as a layperson trying to represent himself against all of the power of the state.
Counsel, please. Being told, don't interrupt the judge, doesn't take a JD to understand. And he interrupted this judge repeatedly. He ignored direct commands to not do this or not do that, and he ignored them outright. So this isn't something, I would hear you more openly if the issues upon which your client was so steadfastly controverting had a substantive nature, but it really didn't matter. He was obstructing everything throughout the entire trial. That was his game plan. Okay?
And even if that conduct was here, the court cannot respond the way that it did in front of the jury. It means he did not have a fair trial, and this court should reverse and dismiss because these charges were minimal that he was ultimately convicted of.
Thank you. Winters versus Atlantic State Development. No, that's submitted. Marunick versus Ray Realty. You may proceed.
Thank you, Your Honor. May it please the court, Michelle Russo on behalf of the appellant's respondents, Ray Realty and Gatsby Enterprises. Summary judgment should have been granted to the defendants on 3 bases. Number 1, there is no evidence in the record to conclude that defendants had any actual or constructive notice of any type of a problem with this specific ceiling.
Did their lack of notice come from their lack of any maintenance? This woman has lived in the apartment for 45 years. A ceiling in a living room doesn't just drop on your head. Normally, ceilings don't normally just drop on your head, right?
That is
So
true.
why isn't plaintiff's arguments regarding res ipsa valid,
Well,
which wouldn't require notice?
no, it does not require notice, but res ipsa in this particular case is inapplicable for several reasons, but primarily because of the fact that the Court of Appeals ruled over 100 years ago, granted, in Slater versus Barnes, that exclusive control must be present in order for res ipsa to apply. And in ceiling collapse cases where the tenant is in possession of the
Well, we know that this disabled tenant, this elderly disabled tenant, certainly didn't cause the ceiling in her living room to fall on her head on her own, right?
Yes, Your Honor, and we also know that there's...
So that means that there is another cause for that happening.
Obviously, Your Honor. However, that does not mean, that does not equate to the cause being the result of my client's negligence. Now, it's true that
But your
the plaintiff...
client's agents testified that there have been a lot of water leaks throughout the building, and yet, despite that, there was no inspection at any time in the 45 years that the plaintiff lived there to see if that might be having any effect on her apartment. Isn't there an issue there?
I don't believe so, Your Honor, and I also am compelled to say that, first of all, the plaintiff lived there, yes, in that apartment for over 40 years. That's correct. There's no evidence that these leaks, which were due to other tenants' activities, continued or were ongoing for 40 years. That's number one. Number two,
I understand,
it was...
but there's no evidence that your client ever looked at her apartment, despite the fact that there had been many leaks throughout the building.
And there was no particulars as to those leaks. I don't know where they were, what line they were in, how soon, how in proximity to this accident were those leaks. I don't have any of that information. And you are seeking summary judgment.
Your Honor, there's no evidence from plaintiff, defendants, that any of those leaks had any effect on the plaintiff's apartment.
How do I know that? I have zero evidence. All I have is that there were some leaks. I don't know where they were, when they were. I have nothing.
That's not correct. We have evidence in the record that the apartment records were reviewed and that leaks were not coming, and the superintendent testified to this as well. The leaks were not in that line where plaintiff lived, certainly not in the apartment above hers.
I thought the superintendent in this case was not the same superintendent at the time of the accident. Am I mistaking this for another case?
There was a property manager who wasn't involved. The superintendent, after the incident, he testified. He was no longer employed, but he testified. He was the superintendent at the time, and he had no notice that there was any leak coming into the plaintiff's apartment.
Am I right that the record reveals that there were also no records kept? So that I have to rely just on the memory of an old employee?
No, Your Honor, that's not correct. There's an affidavit, and there's testimony in the record.
An affidavit is not records, right? Records are, I have a log, someone who testifies that the standard practice of this company is to keep a log of any complaints that are registered by tenants, and there's no such complaint by this tenant. There's no such log here, right? Or did I miss it? Maybe I missed it.
There was a tenant file, Your Honor, that contained,
Yes, please.
that contained records of this apartment, the apartment upstairs, and within that, there were no records of any complaints. Now, I can't produce records from thin air.
Mr. Shaban, who you produced, said he did not believe that his predecessor kept books or records. So why should we trust the absence of records in her file when your own employee said that his predecessor didn't keep records.
No, that's not precisely what he said, but what the records that were reviewed, there are tenant files. There's testimony that there's a tenant file for each apartment. And within plaintiff's tenant file and the tenant file of the apartment above hers, there is no record of any complaints.
But the problem is, we have a witness who says that there was no log of complaints. There may have been records of repairs that have been done, but I saw nothing in the record that said this company keeps a log of complaints.
The logs, Your Honor, are the tenant file. Each tenant file is where complaints are registered.
Okay.
And who, okay.
She'll have time on rebuttal, okay? All right, thank you.
Good afternoon, Your Honors.
Good afternoon.
Okay, so I'm just going to start by, be quick. I'm going to answer some of the things, respond to some of the things that counsel has said. Number one, the super that testified, that was a super at the time, testified he didn't remember about leaks specifically within affecting the apartment. He did not say there were no leaks within that apartment, number one. Number two, the records that she's referring to were not produced. The records they gave an affidavit, and that's part of the problem of his affidavit, that says, I looked at the records and there's nothing in there. He did not touch the records. That's hearsay. Should have attached the records and say, here's a complete file, this is what was in our file, and there's nothing here that would relate to leaks or to repairs or whatever. That's it. Thirdly, one thing I want to respond to is the case she's referring to, Slater, did not hold that you cannot have res ipsa loquitur in an apartment that's occupied. It just says that you must have exclusive control. And let me address that, because that's, to me, is the most important part of this case. Res ipsa there should be summary judgment here based on res ipsa, or at a minimum, there's issues of fact with regard to res ipsa. And that is whether their landlord had exclusive control of the ceiling. They're saying, they're trying, Appellant is taking the very narrow, inflexible, absolute approach, saying just because the ceiling is located in an occupied apartment, then landlord does not have exclusive control. That is not the case. Recent cases in this department have held otherwise, particularly Wenzel, which holds that specifically that a ceiling collapse in an occupied apartment does have the application of res ipsa loquitur, because the landlord did have exclusive control of the ceiling. And
Do we know what caused the ceiling collapse?
no.
So why would this be different from Lisby versus Pell Park Realty?
Okay.
Where this court held that where record was ambiguous as to cause of ceiling collapse, fact issues existed as to the applicability of res ipsa.
Because in Dittinger, there's a holding, it's a Court of Appeals case, that for res ipsa, okay, you're right with regard to imputed notice, but with regard to res ipsa, it is not necessary for the cause of the collapse or the accident to be known. Specifically says in Dittinger that if there's ambiguity as to what caused the collapse, and then there's no problem with applying res ipsa.
Well, sir, I think in line with Judge Manzanet, Daniel's comments, res ipsa provides for an inference of negligence, correct?
Yes.
So the inference may be drawn or it may not be drawn, and Morjan made clear that in the summary judgment context, summary judgment in favor of a plaintiff under the doctrine should be exceedingly rare, saved for very exceptional cases. And so if there is this ambiguity as to the cause, why should we cast aside Morjan's caution to grant summary judgment sparingly to a plaintiff under the doctrine?
Okay, and I think...
And I'll point out, just to add to what my colleague has just said, Dittinger was decided in 1943, and Lisby was decided in 2012. So in 2012, we discerned that where it is ambiguous as to the cause of the ceiling collapse, that raises a fact issue as to res ipsa.
Okay?
Not that it doesn't apply, and I certainly think under the circumstances that a charge would be appropriate here, but whether it is sufficient to warrant summary judgment as a matter of law is the issue, as I see it.
Okay, I'm not really arguing with that because that's my fallback position, that there are issues of fact with regard to race.
Good fallback position.
However, what I want to say on that regard is that the fact that they hadn't looked at the apartments, didn't have a program for inspection, didn't inspect the apartments for a period of approximately 45 years, does indicate a more serious, egregious situation that should result in summary judgment for plaintiff's behalf.
Thank you.
Thank you, Your Honors.
You have 2 minutes, counsel.
Thank you, Your Honor. I would just like to address that it's not true that in the 40 years that she was living in that apartment that they didn't inspect, didn't do anything. Plaintiff testified that 10 to 12 years before this, that ceiling in the living room was painted.
Counsel, no, she said that the apartment was painted. I don't know whether the ceilings were painted.
No,
But the point is that 12 years is still shy of the requirement of painting the apartment every 5.
What I was merely addressing, Your Honor, was the fact that there is not this lengthy, decades-long
No, I don't think
sheer-
that, she said, I absolutely agree with you. She acknowledged that some 10, 12 years ago, at her request, they came and painted the apartment.
Right, and she would have requested it again in this instance, but she wanted to clear out some of her items before they came in to paint. That was her testimony as well.
For 7 years.
It was her testimony, Your
Okay.
Honor. I would also like to address the res ipsa argument with respect to what counsel was saying about this new flexible approach, because although he says, he comments that exclusive control is a narrow and rigid position, it should be pointed out that in Brown and in Lozano, both of which cases Your Honor took part in, that the absence of exclusive control made the doctrine inapplicable.
Were those cases
Ceiling
collapse?
collapse? Yes, they
Okay.
were, Your Honor. Both ceiling collapse cases, and res ipsa was held to be inapplicable in both of those cases because of this, quote, narrow, rigid position that counsel had mentioned. There are no other questions. I rest on the brief.
Thank you.
Thank you.
Dolcimascolo versus 701 7th Property.
I think we had a cross appeal and you gave him 2 minutes. I think we had a cross appeal and you'd given him 2 minutes.
Oh,
He seems to have given it.
okay. You may proceed.
Thank you, Your Honor. Good afternoon, and may it please the Court. I'm Annette Hassapidis, appearing for the plaintiff. In this case, the lower court erred in granting summary judgment and rejecting plaintiff's claims and evidence concerning duress, fraud, and mutual mistake in the execution of the release. Duress, as the Court well knows, is the wrongful threat that deprives somebody of the exercise of free will. I'd submit to you, Your Honor, that threatening an employee with the loss of his job is probably the greatest threat short of threatening physical harm.
Even if implicitly. Go ahead.
Cases that hold that a threat concerning employment constitutes a threat sufficient to determine that someone acted under duress?
This court has held that there were questions of fact in Lopez. In that case, the employee was threatened with the loss of his job and with being reported to Immigration Services concerning his status. This court, Judge Manzanet, you sat on the Paulino case, and there was no threat of a loss of job, but it was an aggressive adjuster who repeatedly harassed the injured party. So there's precedent for it. I mean, frankly, Your Honor, it should be void against public policy when an employer threatens an employee with the loss of his job. When you remove and ignore for the moment that Selena Maddock was an unlicensed attorney, the threat itself should be sufficient to raise a question of fact. When you consider further that this is an injured worker who's of limited means, you know, the fact that the passage of time, the fact that he had time to consult with an attorney was irrelevant. And for the lower court to put the onus on the plaintiff to consult with an attorney in order to, otherwise the threat was vitiated by the fact that he had an opportunity to consult with counsel was erroneous. Consulting with an attorney does not put groceries on the table, let's face it. And this is not somebody who had a bank account who could survive litigation and move forward. So I'd submit to you that my client raised questions of fact with respect to duress and that the court misapprehended and misapplied Paulino. The fact that my client could have consulted with an attorney before he signed the first release was irrelevant. A threat.
What are the public policy implications of this kind of tactic in this industry?
Your Honor, if this decision was affirmed, that an attorney, licensed or unlicensed, could travel to an injured worker's home, fail to disclose their status as a legal professional, secure a release, and
not only for their company, but for the owners and everybody else in the chain of liability having nothing to do with this plaintiff.
Yes, Your Honor, in this case, we protested. Defendants have actually argued that what Navalis did was irrelevant to them. I'd submit to you, they stand in the shoes of Navalis. They are seeking the benefit of a document.
How can they claim that what Navalis did is irrelevant to them when they're seeking the coverage of the waiver?
Your Honor, perhaps counsel can answer the question for us. I know that we've also made arguments establishing that these circumstances were not only unfair by virtue of the threat, but by virtue of the fact that an unlicensed attorney presented herself, did not disclose her status, concealed her identity, and rendered legal advice to my client. We proffered ethical expert opinion in this regard. Deborah Scalise opined that Selena Maddock violated Judiciary Law 478, which prohibits the unlicensed practice of law, RPC 4.3, which is addressed solely to...
My recollection is that defendants didn't counter that evidence. Is that correct?
They counted it with the argument...
No, but I mean with expert testimony.
They did not counter it with expert testimony. The arguments were made that Selena Maddock at the time was a layperson. Now, Ms. Scalise pointed out that under 22 and...
She has a law degree from Ireland.
She had a law degree from Ireland and under...
And she has since been admitted into the practice of the state of New York, no?
Your Honor, she was admitted in July 2018, months after the second release was executed, and she became general counsel for Navalis upon her admission.
I have a question.
Yes, sir.
Does it matter, or would the analysis change if it had been your client that had requested that Ms. Maddock come to him and do exactly what they had done previously in 2016?
No.
In terms of, would it matter?
No, because my client, and I believe, if I have the right page of the record, my client said he knew he had to do this to keep his job from the first time. If the court looks at his affidavit at page 1462 of the record...
So this is the second time that this type of agreement was put before this gentleman after an injury?
Correct.
Okay, go
Yes.
ahead.
After the first... I see my time's up. Can I just give a...
Continue.
Thank you.
While we keep talking, you keep talking.
At page 1462 of the record, he explained that after the first accident, it was implied to him that he had to sign the release to return to the work site. And in fact, when he showed up for his first day of work after the first accident, he had that second release with him. He also testified at page 195, I just needed to sign it so I could keep my job and collect the money each month from them until I returned back to work like last time. And just so the court's clear, he had also signed a release for Navalis to pay him his indemnity payments rather than going through workers' compensation. His workers' compensation medical bills were being paid through the system, but they also presented, and he signed, workers' comp releases for indemnity. So they were essentially bringing him his lost earnings. So that's why he said, I just needed to sign it so I could keep my job and collect the money each month. They were hand-delivering those indemnity checks to his home. And at page 196, I'm sorry, that was 195, this 196, he said, like I said before, emphasis on me signing these documents was based on being told that I couldn't sue Navalis and I would just have a job waiting for me. That's why I signed this.
Thank you. You'll have time on rebuttal.
Thank you, Your Honor.
May it please the court, my name is Nicholas Herzler. I represent the defendants in this matter. Your Honors, this is not duress because it was his idea in the first place. He had a custom.
I'm sorry,
What was his idea?
These releases.
Was the first one his idea?
No.
I seriously doubt this man came up with the idea of releases for the company you represent and all of the other defendants that would have been in line on this case.
He had a 2016 accident.
Right.
He resolved that with 2 releases. He had
At the suggestion of your company.
He had no problem with the whole 2016 incident being resolved with those 2 releases.
So that means it's okay to do it again?
In his mind, it was because he said he first suggested it, and the testimony on that is unrebutted.
Counsel, I'm a little concerned about your telling me about what's in his mind when he also said that he was asked if he understood the document, and he said no. And he also said it was just something I was being pushed to sign. And he also said that he could not go back to work if he didn't sign the releases, and that that's what the attorney employed by your office told him. So I'm a little unsure about how you can tell us with such certainty that it was all fine with him.
It was his, first of all, there's numerous factors that show, well, first of all, if it's going to be economic duress, the record has to show that the claimant had no other option.
They offered him a $3,000 settlement or payment in exchange for being hit with a steel beam.
Your Honor, he
That after this agreement, he came to realize the extent of his injuries.
Your Honor, he was paid $6,000 for the 2016 accident. After the 2017 accident, he said, let's do the same thing we did before.
That doesn't excuse your client, nor does it excuse the attorney employed by your client in participating in this, especially when she signed as a witness to a document that was not signed in her presence. So how can we rely on a release that was signed by that says on its face that it was witnessed when the witness, an attorney, admitted that she didn't witness it?
There's been no argument that he didn't sign these releases. He's always admitted that he's...
That's not the issue. That's not what my colleague just said. This attorney has some serious problems here.
Your Honor, what I'm trying to say is that my adversary...
I am not finished. She witnesses a statement she doesn't watch get signed.
As
And
limited...
now she's counsel for this company? Wonderful.
As limited by my adversary's arguments on appeal, there's no question, they have never said that the releases are invalid for that reason.
Well, no, they did say it was invalid because it was entered into in violation of Section 478 of the judiciary law. So that's part of, and her witnessing something which her signing a document as witness that she didn't witness is one aspect of her violation of Section 478 of the judiciary law.
They may have mentioned that...
They have raised that issue.
They may have mentioned something like that in the statement of facts, but they never argued that that's...
Counsel, there's enough here to refer this to the Ethics Commission, okay?
Your Honor, and just for the record, I mean, this is not my client. It's been said that it's my client. It's not. I'm just to point that out.
You're relying on, your clients are trying to bootstrap to avoid liability by relying on this conduct.
Because
So if you're relying on this conduct, you can't say, oh, it doesn't affect me that it was done in an unethical way.
That's not what I'm saying. I'm just saying that it was repeatedly said that Maddock is my client. I'm just saying.
Sorry. We understand that Navalis is not your client. The problem is that your client is trying to rely on Navalis's actions in order to avoid its own liability.
Because,
So that's a choice your client is making, right?
well, yeah, and it's a choice that plaintiff made. He said in the release that he released us. That was the
No,
decision.
well, he said that he didn't understand that. In your brief, you said he understood that the releases applied to all of you, not just to Navalis. But your only citation for that is to Ms. Maddox's deposition. There's nothing, I couldn't find anything in the record, and you don't cite anything in the record that shows that he understood that it applied to your client as well as to Navalis.
You can answer.
He did. He said,
Where?
he testified, well, first of all, he testified.
Where? What page?
I'm sorry, I have to look and see where exactly that was but he testified at 167, nobody threatened me. He
No,
testified at,
that wasn't the issue. The issue is whether he understood that it relieved your clients of liability. Your
There-
only citation for that in your brief that I could find was
the emails
page
that,
483, which was Ms. Maddox's deposition, not his.
well, that testimony is unrebutted. At 360 to 447, he has emails negotiating this whole thing back and forth. He intentionally set.
That doesn't establish that he understood that it applied to all of the defendants.
And, Your Honor, the case law is clear that if you sign a
Counsel,
release.
I have asked you 3 times. Do you
Your
have
Honor.
any evidence in the record that he understood that this release applied to your clients as well as to Navalis?
Yes, it's in our brief. I'm having trouble finding it right this second, but it's in our brief that he
The only
definitely.
place I found it in
he
your
said-
brief was to
and
Ms.
the-
Maddox's deposition, not to his.
The quote was, from him was, I know I can't sue them. I know that's in there, I just don't have the
Okay.
cite for it right now.
Them not being defined. Thank you. Counsel, you have 2 minutes on rebuttal.
First of all, page 10 of my main brief, I've cited the page references where my client said that he only believed that by signing the releases, he was agreeing not to sue Navalis, which he couldn't do in any event. He knew that Navalis would be compensating him for his injuries and lost earnings through the workers' compensation system. He also testified that he didn't know what contractual indemnity or third party meant. The page references I've provided in the brief are 194 to 196, 1463 to 1464. Plaintiff never said he understood what third party meant. He indicated he never would have signed the release had he known that he was also relieving other parties, that was not explained to him. And with
So under the guise of, we're going to take care of your workers' comp payments, and we're going to give you a little extra for your pain and suffering, they have been able to excise a release that prevents an injured worker under the labor law from seeking redress against strict liability defendants.
yes, Your Honor. Your Honor, they call this
Is
a
that
program.
against public policy?
It should be declared as against public policy. This was open season against Navalis's injured workers. The court's also aware of the conviction of the executives of Navalis for similarly defrauding their employees. That was in October 2021. With respect to the accident, I just want to point out, this was not simply just striking his knee. The beam first struck him in the hands. He tried to block it. He got thrown back against a wall as a result of the impact on his hands. Then the beam bounced on the ground, struck him in the right knee, and the impact on his right knee caused him to nosedive face forward onto the ground.
And for that, he got $3,000.
Well, 6.
6.
2 releases. With respect to the claim that my client knew what he was doing after the first accident, a threat of job loss is continuous. The threat of job loss was made after the first incident. My client knew what the score was. So while there's no evidence or testimony, I think Selena Maddock testified that it was my client's idea the second time. My client knew this is what he needed to do to keep his job, and he's consistently testified to that. And at page 1463, he says, given my experience with Maddock and Navalis, I knew that after my 2017 accident, the second one, I had no choice but to sign 2 releases to return to work and support my family.
Thank you.
Thank you, Your Honor.
Nostalgic Partners versus New York Yankees. We will hear that one first. And counsel on Tri-City Valley Cats versus Houston Astros, you can line up as the second up, okay? You've got chairs in the back. Take your position so we can slide right in. On deck.
Yeah.
In baseball-ese.
The on-deck circle is in the back.
Good
Counsel,
afternoon.
you may proceed.
Good afternoon, Your Honor. Thomas Wisnowski on behalf of defendant appellant, New York Yankees Partnership. 2 weeks before the decision in this case, the Supreme Court held that the professional baseball agreement and major league rules were binding written agreements that govern the nature and duration of the parties' relationship. And those agreements, binding written agreements between the plaintiff here and the New York Yankees, between all major league clubs and all minor league clubs, require dismissal of the breach of contract claim here.
Okay,
Counsel,
so, go ahead, please.
I have a question about the interaction about 2 provisions in 2 of these contracts. In Rule 256, found at page 236 of the record, it says that that is the exclusive means of, that the PDC is the exclusive means of having a contract between a major league team and a minor league team. But then in the operating agreement of the Staten Island, of the predecessors to the current Staten Island Yankees, that they executed in 2007, they defined PDC to include not only an agreement under Rule 56, but also any successor or replacement. That's at page 486 of the record. So I have trouble reconciling those, and I think that so did Justice Ostrager, and that was one of the issues for him in deciding to let the contract action go forward, because it seems like, at least for me, those 2 provisions seem to me very inconsistent. Do you have a way of reconciling those?
Yes, Your Honor. The PDC definition that the court's referring to is the definition of standard player development contract under
Right.
Major League Rule 56. And then it goes on to say, the rule that is its successor, replacement, or equivalent.
Right.
So it's referring to a successor, replacement, or equivalent Major League rule where the standard player development contract might be contained.
And the replacement, the successor, replacement, or equivalent after 2020 was the PDL, no?
No, Your Honor.
Wasn't that conceded?
No, Your Honor, that was not conceded. A PDL is a contract between Major League Baseball itself and a minor league team. The Yankees are actually not a party to PDLs, and the complaint actually admits that. At paragraph 23, the complaint states that after the PBA expired on September 30th, after it expired, Major League Baseball contracts with the minor league teams directly. No major league team can enter a contract with a minor league team. And I would note that the 2011 letter agreement amendment.
So in the 2011 letter agreement, where it included this language or the rule that is its successor, replacement, or equivalent, then is meaningless.
It is not meaningless.
Well, then what does it mean?
If the PBA were renewed.
Tell me what that means.
What it means is that the standard player development contract, if the PBA were renewed, and there were still contracts between.
Does it say that here? All it says, it doesn't say if it's renewed, it says or rule that is its successor, replacement, or equivalent, which I read to mean that whatever replaces the PDC is the replacement equivalent of the PDC, which here is the PDL.
I respectfully disagree, Your Honor, because it
Okay.
refers to a successor, replacement, or equivalent rule. After the PBA expired, Major League Baseball eliminated Major League Rule 56 from the Major League rules. There is no longer a Major League rule governing contracts, and there are no more contracts between Major League teams and minor league teams. Major League Baseball, as the complaint admits.
So in 2011, when Nostalgic bought the Staten Island Yankees, they understood, is what you're saying, that this contract is only going to be alive for 9 years at best, because you entered at 2011 and 2020 is the expiration of the PBA. And so your $8.35 million investment in a minor league team somehow has to be worthwhile in that 9-year period.
Yes, Your Honor.
I mean, to me, look, business is business, right? You don't spend $8.35 million on a minor league team if you think in 9 years the team is going to be poof and you can't recoup your investment. Because I seriously doubt that in 9 years they were able to recoup $8.35 million of their investment in ticket sales at Staten Island.
At the time that the plaintiff purchased the Staten Island Yankees, all Major League teams, including the plaintiff, were aware that the professional baseball agreement expired on September 30th, 2020. The professional baseball agreement and the Major League rules were highly detailed. It governed who the players were, who paid them, who the coaches were.
I got that. Trust me, we've gone through this record. Like my colleague, my concern is, then it seems to me that this language or the rule that is its successor is meaningless, superfluous language that means absolutely nothing in the context of this agreement.
I disagree, Your Honor, because if the PBA were renewed, if the parties to the PBA agreed to renew it, there could have been a successor, replacement, or equivalent rule where the player development contract between Major League and minor league teams could have been found. But the PBA expired and they agreed not to renew it. I know I'm out of time, but if I may, to finish my answer.
I'm going to give you another 30 seconds.
So that successor, replacement, or equivalent language is not meaningless, because if the PBA were renewed, then it could have been in the same rule or a different rule. This agreement, the 2011 Letter Agreement Amendment, refers to a PDC in effect with Nostalgic, the Yankees with Nostalgic. It's clearly referring to a contract between the Yankees and the minor league team. And that's the only way this could work, because now the Yankees are not a party to PDLs. No minor league teams are. So there's no successor, replacement, or equivalent in this case, which is why the court should dismiss the claim.
Got it.
Excuse me, may I ask one question?
Go ahead, please.
Sir, I have one question for you. In your view, how is the 2011 letter agreement inconsistent with Rule 56? If you view it as inconsistent.
I do. It is not inconsistent under our reading of the agreement, Your Honor, because under our reading of the agreement, there was no obligation between the Yankees and Nostalgic after the PBA expired. Under the plaintiff's reading of the agreement, where this agreement created a perpetual obligation on part of the Yankees to affiliate with the plaintiff, that would be clearly inconsistent with the PBA, and it would have been rendered null, void, and without effect under the supremacy provision of the PBA.
Got it. All right, you'll have time on rebuttal.
Thank you.
Next up.
Thank you, Your Honor. Michael Fay for Nostalgic. I want to focus on the definition that Your Honors have been discussing with counsel. PDC, as defined in this 2011 Letter Agreement Amendment. means a standard player development contract as referred to in Major League Rule 56. Major League Rule is in caps. It's a defined term, okay? Or the rule, small r, that is the successor, replacement, or equivalent.
So wait, so you're saying that there doesn't have to be a new League Rule 56 in order for your letter agreement to have efficacy, just that a new rule, whatever they called it, has been put in place and that your standing is in accord with that?
Absolutely, Your Honor, and that new rule exists, and contrary to what counsel's briefs say, it is actually referred to in the new Major League rules.
Where?
It's on page 3 of the 2021 Major League rules. It's defined. A PDL is actually defined in those rules, and then PDL is discussed on a number of occasions in the new Major League rules.
Where can I find that in the record?
There's a citation to it. It's not in the record, Your Honor, but the counsel, you can find it online. You can find the new rules online. It's not actually not in the record.
But if it's not in the record, we can't utilize it.
I agree, Your Honor, but we don't even need to get there because we're dealing with little rule, right? Little rule. We're not dealing with a definition of Major League rule. What is the new rule? Okay, what does rule mean?
You quoted to us from the 2011 amended letter agreement. As far as I can tell, that's at pages 64 to 66 of the record. Is that, but I don't see what you quoted.
Oh, I'm sorry. It's the definition that is carried into that letter, right? Which is at page 486 of the record. Okay.
That's what I was.
All right. And actually at page 485 is the definition of Major League rule. Okay? So what is the new rule? Well, the new rule is that minor league teams have to sign what's called a PDL. That, under our letter agreement amendment, that's a PDC, right? This whole debate that you see going back and forth in the briefs, they say it's not a PDC, we say it is. It's because our definition is different. As Justice Ostrager recognized, this is a unique contract. And this is a contract where they were trying to convince my client to buy the Staten Island Yankees. And as Your Honor recognizes, you're not going to buy a minor league team for 9 years. The value of a minor league team is the affiliation. You want some confidence that affiliation will continue.
It's the affiliation that fills in the seats in the bleachers, no?
Absolutely, because what
I mean, are people coming out just for Joe Schmo baseball team, or is it something different when it's the Staten Island Yankees?
It's Staten Island Yankees, and you have Yankee prospects playing. You can see the next Derek Jeter playing. That's why you come. That's why you pay. That's why you go to the game. That's why you bring your kids, so you can see these Yankees prospects.
And am I right that the bulk of the compensation, the profit that would come from a company that buys a team like this would be from the ticket sales of their preseason games, et cetera?
Absolutely, Your Honor, absolutely. That is the driving force for revenues for minor league teams.
Counsel, I have a question. I appreciate your clarifying that the amended letter agreement, when it refers to PDC, is using PDC as defined in the operating agreement, which is at 486 of the record. But your reading of that definition of PDC doesn't seem to me entirely accurate. It says the rule that is its successor, replacement, or equivalent. But what is the rule that you believe is the successor, replacement, or equivalent of the PDC?
The new rule, okay, once again, since it's not a defined term, we have to use the common sense meaning of rule, requirement, obligation. The new rule for minor league teams, requirement, obligation, is they have to enter into what's called a PDL. And counsel has suggested that that's not an agreement with the Yankees. And yes, it's now with a subsidiary of Major League Baseball, but the Yankees have 7 affiliates now, and they picked every one of those. So that is form over substance. The Major League Baseball isn't telling the Yankees what affiliates to have. They could have made the Staten Island Yankees one of those affiliates, and there could be a PDL in place right now. And as Justice Ostrager said, there is the difference between a PDC and a PDL is a distinction without a difference.
Sir, let me ask you a question on a different subject. How do you answer your friend's point that the 2,000 letter...
Continue. Go ahead.
Thank you. The 2,000 letter agreement violates Rule 56 and should be essentially given no effect?
It doesn't violate it because what it says is you will get a PDC under Rule 56, or you will get whatever comes after Rule 56. There's no violation. Rule 56 doesn't exist anymore. We're not violating Rule 56.
Well, 56 existed at the time you entered into the 2011 letter agreement.
Correct. So it didn't violate it. It just, I mean, again, there are 7 affiliates who got a PDL. Were those violations of Rule 56? I don't think so, right? Things changed. Form over substance changes, but they changed.
Does MLB have the right to reject any transfer of assignment that doesn't conform to the rules as stated by MLB? So in other words, if this agreement between Nostalgic and Staten Island Yankees violated the MLB agreement, did they have to approve this transfer?
No, not at all, Your Honor. They didn't have to approve it, and of course...
Did they object to it? And could they?
Did they object to the
To the language, there's this...
No, absolutely not. Absolutely not. There was no objection. This team was sold. Major League Baseball was fully aware of the sale. They actually, yes, do they have to approve the sale? Yes, they do.
Okay.
Okay.
That was what I was after.
I'm sorry,
So they knew the terms that was in this 2011 agreement. They didn't stop it at its inception. They thought it was perfectly fine.
Correct, Your Honor.
Okay, thank you.
Thank you.
You have 2 minutes, sir.
Thank you, Your Honor. My friend here is trying to change what the plaintiff actually pled in its complaint. At paragraph 23 of the complaint, it expressly alleges that MLB deals with individual minor league owners on a team-by-team basis. Major league teams are not...
That's under the new construct since 2020, correct?
Correct, after the PBA expired. Major league teams are not parties to PDLs. They are not. PDLs are not a successor, replacement, or equivalent rule. The 2000...
What tells, see, you saying that, you're arguing that, but what document tells me that?
There is no, the major league rules that my friend is referring to are not in the record.
I know, but look, if MBL knows that there have been transfer of these teams to different companies, right? And different letter agreements have been entered into, right? I'm trying to understand why MLB would not have said, you're okay to enter into that agreement, but understand that come 2020, this PBA is gone and we start all over.
Because Your Honor, the agreements, the PBA and the major league rules, which the plaintiffs had when they bought the team, say that no player development contract may continue.
But I keep hearing that. My problem is that in your definition of PDC, you add the or, right? So you say Rule 56 or it's successor rule equivalent, blah, 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 right? So that has to have meaning.
It does have to have meaning, and if the PBA were renewed and there were still...
But it nowhere, where in any part of this agreement does it say this or successive rule, agreement, etc.? That is only if the PBA is continued. Nowhere, I don't see anywhere in the operating agreement that says that. Because if it did, I'm with you. That's clear. But I don't see that anywhere. Tell me if I'm wrong, because this is a voluminous record. I might have missed it. Tell me what page it says that this or equivalent rule applies in the way that you are saying. Nowhere does it say the PBA has to be extended for the or rule to take effect.
It does not use those words.
Okay.
What the record, if I may...
Yes, please.
What the complaint says is that after the PBA expired, MLB contracts with the teams on a team-by-team basis. There is nothing in the record referring to any successor, replacement, or equivalent rule. And this is a motion to dismiss, so the court has to look at the record before it. There's nothing in the record talking about a successor, replacement.
But there's nothing in the record that tells me what that rule is either. And that it was at the exclusion, right, of, see, this is what I'm grappling with. It's just missing words that would have made this infinitely clear. But I understand your argument completely.
I have one more question.
Okay, there's a few more questions. Go ahead.
So, Justice Ostrager relied in part in his decision on the offering memorandum on which Nostalgia claimed to have relied when deciding to purchase the Yankees. Do you think that that was improper for him to consider that offering memorandum?
Yes, Your Honor, because that offering memorandum was issued before the plaintiff purchased the team, and the plaintiff signed...
I understand, but didn't the plaintiff's claim is that it relied on the offering memorandum issued by your client when purchasing the team. So why would that not be appropriate for the court to consider in evaluating the contract claims?
2 points, Your Honor. The first is that the asset purchase agreement, when the plaintiff purchased the Staten Island Yankees, contained an integration clause that wiped away any prior agreements or understandings. The second...
Is the asset purchase agreement in the record?
It is in the record, Your Honor.
I missed that. Okay, sorry.
And that contains an integration clause that wipes away any prior agreements. Second, that offering memorandum actually attached the standard form player development contract.
Except that it did not say that all of the clauses of that original contract are at play, right? It incorporated some and left some out. Specifically, 7B was left out.
It was in the 2007 agreement.
I know, but it wasn't in the 2011 agreement. The 2011 agreement, with painstaking detail, referred to which sections were being incorporated. 7B wasn't one of them. Am I wrong?
We disagree with that.
Okay.
The 2011 amendment in part, and it says amendment in part, walks through the first 8 provisions of the 2007 agreement and amends them in part and doesn't amend the rest. And then it incorporates mutatis mutandis, other provisions of the 2007 agreement.
Right, but it didn't include 7B.
It amended 7A. The 2011 agreement amended 7A, but did not supersede.
I keep on talking 7B, and you're talking about other sections. Do you agree with me that 7B wasn't included?
No, Your Honor, because they're one agreement. An agreement and amendment have to be read together. We cite cases on that, including the International Technologies case. The 2007 agreement was an agreement, and then it was amended in part. And those have to be read together. And the 7B clause was not amended. It applies to the agreement and...
Didn't the agreement say we amend blah, blah, blah sections and we incorporate these sections, thereby leaving out those sections that weren't included in, we include these sections?
No, Your Honor. We disagree with that reading.
Okay.
The incorporating mutatis mutandis provision does not have an exclusion language. That incorporates other provisions after the 2011 agreement amendment amended certain provisions in part. And it
Okay,
amended
I'm
7 in
having
part.
trouble with that, but I know that my colleague has another question.
Thank you. If the 2011 agreement is inconsistent with Rule 56, why wait till now to raise that inconsistency? For the better part of a decade, the Yankees have received a benefit, some benefits as a result of being a signatory to the letter agreement of 2011. And now and only now that it's proving to be problematic is this inconsistency argument being raised.
Your Honor, it's being raised now because there is no evidence in this record that anyone understood the 2011 agreement to have a covenant by the Yankees to do anything with Nostalgic after the PBA expired. So under the reading that we submit is appropriate for the 2011 amendment, there would be no inconsistency. And there's nothing in the record that says there is. The plaintiff's reading, Your Honor, would render Section 4 of the 2011 amendment immediately null and void because the PBA has a supremacy clause. And the plaintiffs knew that. When they bought the team in 2011.
Which is why they included the language that was contained in the definition of PDC, which did not appear in the 2000 letter agreement. So it seems to me that they thought that adding the definitional language of PDC from the operating agreement would cover them. So why is that not something that raises an issue of fact that requires a little more discovery to see what people thought they were agreeing to? Since clearly you don't agree on what you were agreeing to.
Well, yes, Your Honor, we don't agree, but we also submit that the plaintiff's ruling, the reading of the successor, replacement, or equivalent language, not only is it not consistent with the language, but that reading would have been nullified by the PBA.
Okay, thank you.
Thank you, Your Honor.
All right, next up is,
Astros.
yeah, the Astros. City Valley Cats versus Houston Astros. You may proceed, counsel.
Thank you, Your Honor. Benjamin Walker for Major League Baseball and the Astros. If the tortious interference claims in this case are viable, then anyone could use tortious interference as a mechanism to compel their own contractual counterparty to extend a contract simply by agreeing to other contracts that depend on its continuation. And that's exactly what the plaintiff is trying to do here. It agreed to a stadium lease with a third party that required the Valley Cats to remain affiliated beyond the expiration date of their affiliation with Major League Baseball and the Astros. They allegedly promised their ticket holders that they would remain affiliated beyond the expiration date of their affiliation. And they allegedly agreed to a contract with their own league, the New York Penn League, that required the league to continue organizing games for affiliated teams beyond the expiration date of the affiliation. So the cause of any breach of any of those obligations was the self-executing expiration of their agreements with my clients on their agreed termination dates, not anything that MLB or the Astros did in restructuring the system after those contracts expired. The law is clear that a defendant can be liable for tortious interference.
Can we talk about the contracts that were entered into with the teams that actually got the PDLs? Wasn't that in violation of terms of the agreement? Because they had to have negotiated with the teams in order to reach an agreement to become one of their PDLs, and that would be in direct violation of the terms of the agreement, no?
So you're referring, Your Honor, I believe, to the fourth contract that I was about to get to that they allege defendants interfered with. That's the National Association Agreement, the agreement among the minor league clubs that were part of the old system. That claim is just as meritless as the others, but
why? For
a different and more fundamental reason, that those negotiations didn't actually breach the National Association Agreement.
How?
Because
how did they not breach?
Section 1903 of that contract was not a promise, as they try to portray it, by all minor league teams that they would all stick together. What it actually says, what it actually means as a matter of law, is something completely different. What it says is that the National Association members who do negotiate to become a member of a competing organization automatically forfeit all rights and privileges conferred by the National Association agreement. So what this actually does is give the parties to the NAA an out, a way out of the agreement. What they bargained for is that if you negotiate with a competing organization, you lose your rights as a member of the National Association. That's a contingency provision.
But that meant nothing because the organization, the PBA, was going to expire by its natural terms, no?
Well,
So that, quite frankly, is meaningless. That is the same for everybody, but not everybody was able to negotiate.
well, it's not meaningless, Your Honor, because it was intended for a completely different situation than this plaintiff is trying to use it for. Clearly, it's a non-compete provision that would prevent a National Association member from joining a competing organization of rival minor league clubs, not from negotiating with Major League Baseball after the expiration of the PBA.
Is
But
that what the provision states clearly?
Yes, it says you can't, what it says is you forfeit your rights if you negotiate with any organization of professional baseball clubs whose existence will in any manner conflict with the letter and spirit of this agreement. There is no way that Major League Baseball's existence conflicted with the National Association agreement. It was the premise of the entire agreement. So this was not the
So
situation.
you're saying that as 2020 approached, every single minor league team was free to attempt to negotiate with major league teams to become a PDL of those teams? Is that what you're saying?
Yes, they were free to do so, but they forfeit their rights under the National Association agreement. The reason that is important,
But again, that right is really meaningless since the contract of the PBA was about to expire.
well, one could make that argument under these particular
But
facts.
it's not just an argument, it is a factual reality.
Well, that doesn't make it meaningless in all circumstances, which is what matters under the law. The provision had meaning.
What circumstance would it be meaningful?
If there were a competing organization of minor leagues that rose up to try to compete with the National Association, and minor league clubs that wanted to join it, they could do so, but then they would forfeit their rights under the National Association agreement. There would be meaning to that. And this court held in the Two Rivers decision last year that a provision like that says you lose your rights if you do X cannot be breached. That just gives rise to a contingency, a condition that doesn't give rise to a breach of contract claim, so it can't by definition give rise to a tortious interference claim. This plaintiff actually must have agreed with that, because if you look at paragraph 44 of the complaint, which is page 38 of the record, they say that in the run-up to the creation of the reorganized system, they negotiated with MLB and the Astros to join the new system. So if they negotiated to join the new system, then they forfeited their own rights under the National Association agreement. In their world, they breached the National Association agreement, and now they're turning around and saying that other clubs that did so at the behest of Major League Baseball in violation of tortious interference law. So that is not just semantics, as Justice Ostrager called it. This is a clear legal difference between a breach of contract and a forfeiture of rights under Section 1903. And then Section 801 of the National Association Agreement provide to the National, excuse me.
You can continue, go ahead.
Okay. It applied to the National Association itself, and it prevented the National Association from becoming party to an agreement that would result in the cessation of operations of any member league or club. They don't allege that. What they allege is that the National Association was circumvented by Major League Baseball, that it was not a party to an agreement. So there's no violation of the National Association agreement. Thank you, Your Honors.
Thank you. You may proceed.
Thank you, Your Honor, and good afternoon. I'm Greg Silbert from Wild for the Valley Cats. For over 100 years, minor league baseball was an independent organization separate from Major League Baseball that protected the interests of minor league clubs like ours.
But Major League Baseball didn't have to continue to follow that structure, did it?
Major League Baseball did not have to continue to affiliate with minor league teams, but minor league baseball was a separate independent organization until 2020. Today, minor league baseball is a wholly owned subsidiary of Major League Baseball, And where minor league baseball used to protect the interests of minor league clubs, it now serves the interests of Major League Baseball and its clubs. And so
We
that,
understand that, but the question is whether or not that's legal and enforceable. And I don't understand your argument as to why it's not.
it is not enforceable because minor league baseball as an independent organization, put aside affiliation, assume there's no affiliation.
No,
Minor
you
league
can't put aside the affiliation. Isn't that the whole point?
affiliation, as you said in the prior.
As I said earlier, nobody's going, other than people, local people, they're not going to go to see these games unless they are affiliated with an MLB club.
And you're certainly right, Your Honor. It undoubtedly affects the economics, but we
Right.
had a separate
And
organization.
at the end of the day, certainly with the last contract, they bought a team for $8.35 million. I suspect your team is no different, that the economics are at the forefront of every business venture, including this one.
Yeah, absolutely, Your Honor, but at the forefront of the tortious interference with contract claim is a contract that was breached because of the acts by the defendant. And the contracts that were breached here were, number one, the National Association Agreement. As you said, Your Honor, there was a provision of the National Association Agreement that prevents member teams, member clubs, minor league clubs, from negotiating in a way that conflicts not just with the interests of the minor league, but with any club within the minor league, including.
Can you address your adversary's argument that your client attempted negotiations themselves? They obviously didn't win in those negotiations, but they too attempted the negotiations, so they are hard-pressed to point the finger at others who did the same and were successful. Is that not sour grapes, and why not?
It's not just sour grapes, Your Honor. This plan from the start, and unfortunately it was a successful plan, was for Major League Baseball to eradicate completely what used to be minor league baseball, which was the National Association. The National Association and minor league baseball were one and the same. Major League Baseball came along and said, we're bigger than you, we're richer than you, we're more powerful than you. We don't want an independent minor league baseball anymore. We want to own it. And it took it over and it said, now, unless you, if you'll forgive the expression, play ball with us, we will wipe you out. We will impose crippling economics on you, and you have no choice. So under those circumstances, where our only means of survival as a minor league team at all was to affiliate, yes, we tried to affiliate, because they told every team, unless you abandon what used to be the minor league system, where the minor league was independent and protected minor league clubs, and you join our new system, where we own the minor league and it protects major league clubs, you're going to regret it. And so, yes, we tried to because that was our only opportunity, but that's because they have all the power. Now, as to the second provision of the NAA that was breached, that's 801. It says the National Association cannot enter into any contract or agreement that would result in the cessation of a league or club within the minor league. Here's what we know, okay? Minor League Baseball was a trade name. It was owned by the National Association. The National Association owned the website Minor League Baseball. It owned all of the intellectual property. It performed all the functions that would have to be done to operate an independent and separate minor league. It scheduled games. It resolved disputes between teams. It disciplined minor league players who broke the rules. All of that, to our understanding, is now done by Major League Baseball because Major League Baseball literally now owns minor league baseball. So what agreement accomplished that transfer? Well, before discovery, we don't know. But you give us some discovery, there definitely is an agreement out there that has that effect because the independent system of minor league baseball was wiped out, and it is now a system that Major League Baseball owns. There has to be some agreement that formalizes that transfer, and once we get some discovery, we can identify it for you. More generally, my friend on the other side says, well, all we did was sit on our hands, let a contract expire, and that's what you're mad about. Well, no. If that's all they had done, three things would be different, and each one is important. Number one, if all they had done is let a contract expire, then minor league baseball would still be an independent organization separate from the major league, and its mission would still be to protect minor league clubs instead of serving the interests of Major League Baseball. Number two, if all they had done is sit on their hands and let a contract expire, then we would still be a minor league team. And we are not a minor league team today because they own the minor league now and they kicked us out of it. And number three, if all they did was sit on their hands, we would still be playing other minor league teams in the New York Penn League. And we are not, because they got rid of the New York Penn League because it did not serve the interests of Major League Baseball to have one. My friend says that the stadium agreement talked about affiliation. It also said in section 4.1 that we would lease the stadium to play a Class A short season New York, as a Class A New York, Class A short season New York Penn League team. We are not a Class A short season New York Penn League team because there is no New York Penn League because they eliminated it. It's also why the New York Penn League is not honoring its obligations to us. There is no New York Penn League. There was, the independent minor league had one. When they took over the minor league, they didn't want one, so they eliminated it. So the New York Penn League cannot meet any obligation to us because it doesn't exist, and it doesn't exist not because they allowed the PBA to expire. That wouldn't get rid of the New York Penn League. It doesn't exist because they took over the minor league.
Thank you.
Thank you, Your Honor.
By conceding that the Valley Cats did try to negotiate with MLB and the Astros in a manner that the Valley Cats claim was a breach of Section 19.03 of the NAA, counsel just conceded that they forfeited all rights that they had under the National Association Agreement, including any right to bring a claim for tortious interference with that agreement. So there can be no conceivable basis for any claim that we tortiously interfere with the National Association Agreement, since they forfeited all rights that they would have otherwise had under the agreement. Beyond that, Section 8.01, counsel claims that there would definitely be an agreement by the National Association if they were to get discovery. But the agreement that they would need to establish is an agreement that results in the immediate cessation of the operations of a member league or club. They can't allege that. They can't show that. No discovery could possibly show that, because their own allegations are that the National Association was destroyed by Major League Baseball's plan. That alleged action, letting the PBA and the PDCs expire, is what would have led to the end of the National Association and the cessation of any league or club that was no longer operating as a result. With respect to the notion that if Major League Baseball hadn't done what it did, the New York Penn League would still be operating. The point is that all of the allegations in the complaint is that those agreements cease to have meaning, those leagues cease to operate, the clubs cease to have a reason to keep playing because they no longer had an affiliation. That was the result of the PBA and the PDCs expiring under their terms. That's what, when we say that we sat on our hands and did nothing, the point is that that is the action.
No, you sat on your hands, you allowed the minor league baseball teams to build up the minor league franchises, and just as it's getting good, let's take them over. That's what happened.
No, we disagree with that, Your Honor, factually. That's not true.
I mean, you may be contractually sound, but we have essentially wiped out an independent minor league.
We disagree with that, Your Honor, as a factual matter, but we're here on a motion to dismiss. And as a legal matter, even if you concede everything that they say in the complaint, there is no legal basis to bring a claim for tortious interference, because nothing we did caused a breach of any contract that they allege in the complaint.
Thank you.
Thank you.
Casino towing versus New York City Department of Consumer.
His case. He's getting on deck.
Good afternoon, Your Honor.
Good afternoon.
Alexander Kelly for the appellant, Casino Towing.
You may proceed.
Certainly, the Yankees and the Astros are a hard act to follow. This is a relatively simple case. This is just a matter of whether or not the Department of Consumer and Worker Protection should be required to follow the law. And the law that they should be required to follow are Section 2203 of the New York City Charter.
How about the law that you maintain insurance, that your client maintain the proper insurance required for a towing company?
Well, so
That was clearly violated here.
it's an interesting issue. It is correct that my client arguably violated the law.
Well, not arguably. It's not even arguable.
Well,
He has to maintain a certain limit. He submitted on his renewal application proof of the proper limit, and 4 days after submitting that application, reduced his insurance limits by half. That sounds like a slam dunk to me.
So the application was submitted, a paper application, hard copy, was submitted on April 9th, 2021. The only insurance certificates that existed at that time, and it is a requirement to submit a certificate of insurance along with the application, was a certificate of insurance that showed that my client was carrying $1 million in coverage. The department issued subpoenas to the insurance company and the insurance broker, which confirmed that on April 9th,
But
they
before
were
we get to
carrying that.
subpoenas,
I'm sorry?
after that, your client requested his broker to decrease his coverage, right?
That's correct, on
And then-
April 17th.
And then he decreased the coverage, and whether it was the right amount or not, the rules very clearly require that whenever there's a change in coverage, the towing company has to notify the agency, and your client did not notify the agency, right?
And my client concedes that, that's correct.
So why isn't that enough to lead to suspension?
Because there is a schedule of penalties that's established under 6 RCNY 2-362D, which provides specific penalties for those exact violations. And my client concedes the violations, although it is arguable that the $500,000 CSL policy that they were carrying exceeded the limits that are established under the 2 sections of law that they're accused of violating, which both require not combined single limit policies, but split limit policies in the amount of $200,000, $500,000, $50,000 per accident. My client reduced their coverage from $1 million to $500,000. It is correct. As I mentioned, there is a schedule of penalties that clearly lays out penalties under both statutes. New York City Code 20-500.
Are those set in stone, or?
They are set in stone. It's the law.
And there's no discretion?
First of all, there's no finding of a violation anywhere. And there is a requirement under Section 20-504 of the Administrative Code that there be a finding that a violation has been committed. There is no such finding. There clearly has been a delegation of the Department of Consumer and Worker Protection's authority to hold adjudications to the Office of Administrative Trials and Hearings under 6 RCNY 6-01. There was never a notice of violation served. The notice of intent to deny their license renewal application is not a notice of violation. It was not made returnable before the New York City Office of Administrative Trials and Hearings. And 6 RCNY Section 6-01 was amended in March 2021 to indicate that it certainly contemplates all proceedings in which the department seeks discretionary revocation, suspension, or denial of a license. Under New York City Charter 2203, the Commissioner of the Department of Consumer Affairs has the right to perform an adjudication, but only upon due notice and hearing. There was no hearing held. And as I mentioned, 6 RCNY 6-01 contemplated a complete transfer of the entire adjudicatory function of the Commissioner of the Department of Consumer Affairs. This should have been handled by a notice of violation made returnable at oath, and the penalties that were imposed exceed the schedule of penalties that are provided under 6 RCNY 6-36 clearly. So it is an issue, the law is extremely clear. This is an issue of whether the courts are going to require the Department of Consumer Affairs or now the Department of Consumer Worker Protection to follow the law. That's it.
Thank you.
Thank you.
You may proceed.
Tahira Sadria on behalf of the Department of Consumer and Worker Protection.
Counsel, could you address the point raised by your friend that this was not an appropriate penalty for the admitted violation of failing to advise the agency of its change in insurance coverage?
Okay, I think that the easiest way to address this is that there are two strands of authority that the Department of Consumer and Worker Protection has. It has the authority to, that is granted under the city charter, section 2203, to impose civil penalties following a hearing. And it is that authority, okay, so that's one strand, is the ability to impose penalties following a notice of violation. The second strand is the management of licenses. That is not so management of licenses is does not require a hearing. It's like the ability to deny a license, grant or deny a license, to deny renewal of a license and impose suspension in the connection with the tow truck industry is governed by 20-504, which does not require a hearing. It provides that the agency may take these actions upon due notice and an opportunity to be heard, not an opportunity for a hearing. The agency regulates some 40 different industries, and there are some provisions of the administrative code which do require a hearing prior to a determination to revoke or suspend a license. In those cases, so, okay, I'm sorry, I'm going to go back again. An adjudication, though, is defined.
My question was a much narrower one, which is, why is a 3-month suspension an appropriate penalty for conduct of the petitioner?
The penalty, the 3-month suspension is appropriate because what we have here, the conduct here goes to the heart of the agency's regulatory authority. The agency granted the license based on a representation that the company was carrying the appropriate amount of insurance. And then 4 days later, the amount of insurance is reduced below the legal limit.
Is there a statutory authority for the agency to suspend a party?
Yes, 20-504
okay.
provides that authority. The requirement under 601 for a hearing, I mean, the requirement that an adjudications be held at oath applies to adjudications, which are defined as determinations that must be made by law following a hearing. And the determination to suspend a license under 20-504 is not required to be made following a hearing. And again, given especially that we're talking about an industry that is dealing with people who do not have the opportunity to compare and contrast and choose who they're in. These are people who are in distress and so are particularly vulnerable to unscrupulous actors. And so being able to regulate and ensure that there is adequate insurance, ensure that the company is an honest actor is very important to the agency's ability to regulate in the public interest.
Thank you.
Thank you.
Counsel, you have time on rebuttal.
So I would just like to point out a couple of things very quickly, which is that final determination itself concedes at page 60 of the record that there is an ambiguity in the record of exactly what happened here, and that the lowering in coverage, which did not occur 4 days after the application was submitted, it occurred on April 17th pursuant to the final determination's own findings of fact, which is still a short period of time, may have resulted from a miscommunication between the staff at DCWP, then DCA, between my client's staff and between their insurance broker, who was also communicating with them. There are emails attached to the record that show that the insurance broker was communicating with DCA at that time on behalf of other towing companies as well, because DCA promulgated a new rule in 2018 without following CAPA.
Excuse me, are you trying to say that your client can be excused from this because his insurance broker made a mistake? Isn't he bound by what he submits?
I'm sorry, Your Honor, I didn't hear.
Are you saying that his conduct is acceptable because it was actually the insurance broker's mistake, not his mistake?
No, I'm saying that the final determination itself concedes at page 60 of the record, DCWP's own final determination concedes specifically that my client may have lowered his insurance coverage because of a miscommunication between himself, DCA staff, and his insurance broker. There was a lot of confusion regarding this rule, which wasn't promulgated properly in 2018. They did not file CAPA to promulgate the rule.
Excuse me, counsel. Was there any confusion about the rule that any change in insurance coverage had to be reported?
No, and there's a violation that's established for that, and a penalty under the schedule of penalties that's provided at 6 RCNY 6-36. I don't think the court should ignore the fact that DCWP has been failing to enforce the law as they are now trying to enforce it against my client since 1987. They've been accepting insurance in a different amount than the insurance that's required under New York City Code 20-500C and 6 RCNY 2-362D. From 1987 until 2018, they were accepting 300,000 combined single limit policies. And since 1987, then they promulgated the 2018 rule, which they concede in their papers was erroneous for reasons outside the record, et cetera. But since 2018, they continue to accept insurance coverage that does not comply with New York City Code 20-500C and 6 RCNY 2-362D because they continue to accept $1 million combined single limit policies, which don't provide coverage necessarily for more than one person involved in an accident. And so the agency has a long history of arbitrary and capricious behavior here and violating the law and exceeding their jurisdiction and failing to follow CAPA, both in the way that they perform their adjudications and also in promulgating these bogus rules that they have promulgated. And this final determination is based in part on this long pattern of arbitrary and capricious behavior.
Thank you.
Thank you.
Okay, IS Christie Management versus ADP. Judge Gesmer is recused from this matter, and we will follow the court rules should we need an additional vote. You may proceed.
Good afternoon, and may it please the court. Bill Jives on behalf of defendant, appellant, respondent, ADP. Your Honors, the court below erred in declining to enforce the clear and unambiguous terms of the limitation of liability provision so as to preclude plaintiff from recovering its alleged consequential damages. The Court of Appeals has clearly instructed that in the context of a pure breach of contract dispute involving sophisticated corporate entities, no public policy is offended by a contractual provision that limits a party's liability for gross negligence or willful misconduct, provided that provision does not go to the next step and essentially immunize that party from any liability. The Court of Appeals has indicated in Deutsche Bank that if a limitation of liability provision falls in that basket, it's enforceable and should be enforced as written. And I won't repeat the arguments we make in our papers, but I submit to you respectfully, the limitation of liability provision at issue in this case falls in that basket. And it should be enforced as written. Now, Your Honors, we've briefed these issues not once but twice, and I want to be respectful of your time this afternoon. I would like to just address one issue on my appeal, certainly address any questions you have, but then I'd like to focus on the cross appeal.
Sure.
Okay, the only point I would make in addition to what we've already stated in the briefs is on the question of whether or not there were judicial admissions made below. And we've briefed that thoroughly. The only thing I would add to it, Your Honors, is that the judicial admissions we allege were made are consistent with statements that I.S. Christie made during the course of fact discovery. And specifically, I'd refer you to page 223 of the record. And that's essentially an interrogatory served during the course of discovery, standard interrogatory that basically says, plaintiff, identify and describe each element of your damages. And in response to that ROG, I.S. Christie essentially said, we've suffered direct damages that are the fees we paid, the fees we paid under the MSA, and then a host of other damages, including the settlement costs and the underlying class action. I submit to you that that statement in fact discovery is consistent with the judicial admissions that we claim were made in the briefing here.
Was this a judicial was this an admission of a factual matter?
The ROG response or the judicial admissions we talk about in our
The
briefs?
ones you talk about in your papers?
Your Honor, I, for the life of me, can't see how they're not factual. A legal argument in the damages context would be something like, we're entitled to consequential damages. That's not what they said. What they said numerous times, directly, clearly, without equivocation, is we sustained $641,101.06 in consequential damages. That's not legal argument. That's a statement of fact. I submit to you.
Doesn't that statement require some legal analysis as to what would constitute consequential damages? Because all of the cases that you cited with respect to this issue dealt with actual factual statements, right? Brown involved whether the defendant was seen to purchase cocaine. Matter of Union involved whether officers and directors made material omissions and misrepresentations regarding the operations and condition of the company. And in GJF, whether the plaintiff was an additional insured. All of those are factual matters, not legal determinations. And the sum that you refer to is not just a factual matter. It's something that has to be, you have to come to it after going through an analysis, correct?
Your Honor, let me try to respond this way. I disagree. I think they were factual statements. But if there's discomfort here about saying there was a judicial admission, I believe this court, as a matter of law, can indicate what was consequential and what was direct. It's done all the time. It's done even on motions to dismiss. This is summary judgment. Biotronic did it. Judge Cote downtown did it in China Grill, most recently in the NORAD case that we submitted as supplemental authority. The court in that case in Atlanta, if I may just finish my answer. The court in NORAD down in Atlanta looked at virtually an identical limitation of liability provision. And the plaintiff in that case, similar to this case, sued to recover the cost of defending and settling a series of class actions in California. And Judge Ray in Atlanta basically said, look, this is clear under New York law, and I believe he is right on this, is that the direct damages in this context are the fees paid. Okay, that's the value of the service that you claim was not properly provided. Everything else is at least...
But except the problem is that when you hire someone to do a job, you complain about an issue, and they say, don't worry, we fixed it. Isn't that an additional damage other than the fees that was paid? Because they had other expenses as a result of that error. right?
Sure. Those are consequential. Those damages may flow ultimately from ADP's alleged breach, okay, but they don't flow directly. They're a step or two away causally from the breach. And they say it in their brief.
But for the breach, they wouldn't have had those costs, right?
I submit to you that that's not the standard, okay?
That's not what?
That's not the standard here.
Okay.
The question is whether or not, and they say it in their brief, I'm going to walk away from this.
That's okay. I do the same thing.
I really can't see it. In their brief, they say, as a result of the imperfect services, okay, there was a violation of law, and that law caused the litigation, and it caused us to retain these consultants. That's 1, 2, 3 steps removed from the breach. Those are consequential. I'm not claiming that they're not entitled to receive those, but for the limitation of liability provision. But the direct damages here are the value of the services they claim were defective. Okay. And the best way to value that is the fees they paid.
Got it.
Thank you, Your Honor.
Thank you. You may proceed.
Good afternoon, Your Honors. May it please the Court. Y. David Scharf of Morrison Cone for the respondent, cross-appellant I.S. Christie. We could write a law review article on whether Deutsche Bank applies or not, but there are 4 small issues that I'd like to point out because I think we briefed it. The first point I'd like to address is the fact that this notion that we have sophisticated parties with equal bargaining power having negotiated this agreement is belied by the record. There was an admission in the deposition by the ADP witness that said there wasn't a negotiation. In fact, the second point that I'd like to make is to point out—
With regard to the contract, you mean?
Yeah, with regard to the contract. It's a form contract. We look at the agreements that were entered into during this period of time, and they start appearing at page 247, but I would draw Your Honor's attention to 250, and then compare page 250 with another contract for different services at the same time that appear at 282. I'm a very visual person, and this struck me as extremely stark. The limitation of liability provision that they are saying should be read together, and this way it falls into Deutsche Bank, is at 250. And as we've pointed out, there's a section 6A and there's a section 6B. Now look over at 282 on the record. It's over on the left-hand column, liability, A, 4A. That is the integrated provision where you have both the agreement that they are going to limit consequential damages and be limited to fee damages, set up extremely differently than it is in the contract provision that we are dealing with. But part of the beauty of it is Justice Ostrager did not do any injustice to Deutsche Bank, assuming Deutsche Bank was to even apply here. And we argue, obviously, that it doesn't apply. But if you look at Justice Ostrager's opinion, at pages 9 and 10, nowhere does he use the word gross negligence, which is the only issue that the Deutsche Bank case dealt with. He's very careful. He talks about willful misconduct and fraud. And the reason why he talks about that is because it is consistent with his motion to dismiss decision, allowing our case to continue. It picks up on my adversary's arguments to the court on the original motion to dismiss, which preceded Deutsche Bank, where he said there's no need for a fraud claim because there is an exception in 6A that says that in the event there is willful, criminal, or fraudulent misconduct, then there is an exception to the limitation of damages. And what ADP, who is really seeking to enforce, in my mind, a contract out of adhesion, not negotiated. You want ADP to services, sign our agreement, here's our form agreement, and it was not negotiated. And my client didn't have bargaining power. It didn't negotiate it. But
Well, there is a difference between not trying to negotiate something and not having bargaining power.
Correct, but
usually that doctrine is meant to protect consumers, not sophisticated commercial entities.
Our client is no different than any other motel or hotel operator that wants to utilize ADP's payroll services. Yes, our client was going to have 500 employees. They knew it, and what they did, as Justice Mazonet pointed out, they completely not only abdicated their responsibilities, they lied to our client about what they were doing, that they had remedied it. They put people who were incompetent and unqualified to do the work, and then they come to this court because Deutsche Bank came down in the middle of this litigation and say, well, just treat gross negligence, treat fraud, treat willful misconduct, all one and the same. We're exculpated from liability. You can have $123,000 because that's what you paid to us. I would point out, my adversary pointed to page 223 of the record, the interrogatory responses. I think this completely supports our position. Interrogatory number 15, with respect to the approximately $1 million in compensatory damages you claim to have sustained as a result of ADP's alleged breach of contract. Classic direct damages. I see if
Continue.
I just make this last point, and I'll save the rest for rebuttal. We say we respond approximately $490,000 in damages attributable to the payment to settle claims brought by a class of former public kitchen employees affected by the inaccurate wage notice and statements generated by ADP. No admission. In fact, it's right on to show that it's direct damages in accordance with the Court of Appeals decision in Biotronics.
Thank you. You have 2 minutes.
Thank you, Your Honors. This notion that I.S. Christie is a widow or orphan is
I didn't hear that, but go ahead.
The notion that I.S. Christie was not a sophisticated player in this situation is ridiculous. Ian Schrager, I grew up in New York. I'm familiar with Ian Schrager for years. This could be the first time that anybody has ever accused Ian Schrager of being any other than a streetwise, sharp, smart operator. And his operation is no different. This was a negotiated contract. The fact that you don't ask for a change in the limitation of liability provision doesn't mean that it was handed up, take it or leave it. That's not the case. I can tell you that firsthand. I defend these cases a lot. They are negotiated. They chose not to. That's their problem. It's too late to complain about it. Very quickly, Deutsche Bank definitely involves more than just gross negligence. The gross negligence exception is a misnomer. Okay, and Justice Manzanet, you've touched on this in prior cases. The gross negligence public policy exception includes fraud, it includes recklessness, it includes gross negligence. So anything that they're alleging here factually.
But which is why I am disturbed by ADP's statement, we fixed it, when they hadn't. That's a problem. That's a real problem for you.
I think, I understand, Your Honor, but again, are we talking about a factual allegation in support of a breach of contract claim? That's one thing. If they're thinking that they have made out a fraud claim here, I think for reasons that Judge Ostrager has touched on, it's duplicative in a number of ways. It does arise out of the same subject matter as the breach of contract claim. Same damages.
It's not the same damages. You said before that those additional damages were consequential, right?
Yes.
Okay, so they're not direct. They're not the direct, they are an offshoot of the misstatement that we've taken care of it.
Consequential damages are recoverable in a breach of contract claim.
I understand that.
Right.
And the issue is whether this can be an appropriate damage under a fraud cause of action.
Right, and I would just submit to you again, I know my time is up, but just to summarize, same facts as the same subject matter as the breach of contract claim, same damages, okay? The only damages we've ever heard about are the $747,000. We've never heard about any other damages, and no independent duty outside the four corners of the contract.
Thank you.
Thank you, Your Honors.
You have 2 minutes.
Thank you, Your Honors. I have 3 quick points. First, Deutsche Bank did not overrule Kalish versus Jericho, 58 New York 2nd, 377, which explicitly said when there is fraudulent, malicious, or improper intentional wrongdoing, there cannot be an exculpation of liability. That's what we have here. We also have Deutsche Bank itself. When it talks about the policy of why in Deutsche Bank, a dispute between Morgan Stanley and Deutsche Bank, arguing about mortgage-backed securities, they said the reason why it was not an exculpation provision because the buyback issue that was in that case put parties back to the place where they would have been had they not entered into that contract. And therefore, nominal type of damages, okay, were something where the public policy was still going to apply. We have $1 million worth of damages here. They're saying you get back the fees that you paid us. That doesn't put us back to where we belonged. And we actually believe that Justice Ostrager got it wrong when he said we couldn't go to trial on a fraud claim because, as we set forth in our brief, in our reply brief, it's on page 4, they said they had set up a benefits accrual policy when they had not. They said they had spread hours, set up was complete when in fact it wasn't, and they omitted to tell us 2 other aspects as it related to the Metro Computer Transportation Mobility Tax and the multi-jurisdiction to properly calculate residency tax. Justice Moulton in BML, props, at 174 AD 3rd, First Department in 2019 said that supported an independent fraud claim. And Your Honor, if I may just conclude,
Go ahead.
Judge Mazonet, in the case of Sutton Gate Holdings versus Lancon Management, a post-Cronus decision, Your Honor agreed that if there's a fraud claim based upon focused on events following the execution of agreement, it provides for independent. We get to go to a jury on both of these issues.
Thank you.
Thank you, Your
Thank
Honor.
you both. Okay. People versus Jermaine Trailer. Please wait for Justice Gesmer to return.
I did it. Oh, okay.
Good afternoon. You have 5 minutes.
Good morning.
Good afternoon.
Good afternoon. I'm used to the mornings. But anyway, good afternoon. May it please the court. My name is Justin Bonus on behalf of Jermaine Trailer. Look, this case, it really embodies a man who came home from prison. First night he goes out, he gets drunk, he violates curfew, there's no question about that. Gets into an altercation with his nephew's friend. And the items that he has in his hand, when we want to talk about intent, has to do with an entirely different altercation. It has an interaction. Well, I should say, an entirely different interaction that was an altercation with Giovanni Ortiz. Mr. Alam, there was no altercation. I mean, even from Mr. Alam's...
But he threatens the man. He's kind of chasing him around his fruit stand. I mean, I'm sorry. A golf club could clock your lights out, okay? If you get hit in the head with a golf club, that's a problem. So this isn't just, him screaming at him with empty hands. He's got 2 items in his hand that could cause some serious damage.
And I understand that, Your Honor. That's why there was never a challenge to the potentiality that these things in his hand could cause damage. But the issue is they're not inherently dangerous. And the intent was more towards Giovanni Ortiz.
But Giovanni was gone. Giovanni was I'm sorry. Look, this is probably one of the worst criminal cases I've seen, right? Because this could have been totally avoided, okay? I get that. But at the end of the day, Mr. Alam was quite concerned for his safety, and deservedly so.
Well, the question, and that's the interesting point, is are we talking about what Mr. Alam thought, or are we talking about Mr. Traylor's intent? So the prosecution, the people have to prove that he has a specific intent to cause either fear when you're talking about menacing.
I believe the victim said, he said to him while chasing him around, "I'm gonna kill you."
No, that's not true, Your Honor. Specifically, Mr. Alam said the only thing that he understood Mr. Traylor to say was yes or no, yes or no. There were, Mr. Cedeno, I think, may have said that in his testimony, and Mr. Cedeno's testimony was, allegedly he's standing right next to Mr. Alam and Mr. Traylor at one point. You can't hear anything on the 911 call, which was in evidence. The other thing is, Lieutenant Pryber was on the block for several minutes, and when he walks up to the scene, Mr. Traylor, he can't hear what they're saying. He doesn't see Mr. Traylor committing a crime, okay? So the question is, what was Mr. Traylor's specific intent? Was Mr. Traylor drunk? It appears so. He had several drinks, hadn't been drinking at all. And I think this rolls into the other arguments that I'm making with regard to, forget the fact that Mr. Alam completely testified differently in front of the grand jury, which is a whole other set of circumstances, and he was really the sole evidence in front of the grand jury.
All of this was in front of the jury, though, right? And so...
Not the grand jury, not the grand
jury.
No,
but the jury, he was cross-examined on this issue, on all these differences, all of these, and again, I say this to you completely understanding where you are, okay? This is not somebody who should have ended up in this position, okay?
I didn't say he was a smart man.
Right.
This is.
Look, I get it. I'm guilty of not being smart. I get it. The problem is we have a jury who has listened to all this evidence and determined that it is enough. Why are they wrong? And what is in here that would allow us to supplant the jury's verdict?
And that goes into the jury instruction. And the jury, note 3, because I'm the one that tried the case.
Right.
By note 3, I thought the jury was actually buying the argument that I was putting in front of them. I hate to use that term, but my argument was this is a misunderstanding, and a man that's intoxicated and a man who doesn't speak English. Put them together, and it was a terrible situation. And that's conscious objective. Was his conscious objective to put Mr. Alam in fear, to use these items, to threaten or with dangerous intent? And Judge Klott, he gave an interpretation to the extended intent, if I may, just to finish my thought. And then intoxication, we all agreed to follow the McKinney's specific, I had no problem with that. How many drinks? How long, had he been drinking before that, So Judge Klott just deviated from that. And I think that's the question here, is you just hit the nail on the head. Is the jury got a different jury instruction by the end, by jury note number 3. And that changed everything else. It changed their ability to analyze the case the way they should have, which is what the statute says, what the jury instructions say.
Okay, thank you.
Good afternoon, Your Honors. Sylvia Wertheimer for the people. The fact that, as Your Honor said, the jury heard all the evidence in this case and appropriately concluded that the evidence supported the charges. The defendant here, there was inherently aggressive conduct. He was wielding a metal golf club, broken bottle.
Was the golf club raised in a position like to strike?
Well, it was, the testimony was that he was waving it.
Okay.
And one of the witnesses said that it was over his head. That was what Mr. Hasib said. But definitely, the testimony repeatedly was that he was repeatedly waving it. And the testimony was that this fruit vendor...
Waving it to strike at Mr. Ali?
As if to strike at it.
Okay.
That's what, I mean, you end up, Mr. Hasib, who speaks Bengali, says that he hears the fruit vendor say in Bengali, "Don't kill me." So he's doing that because this person is coming at him with a golf club and the metal bottle. It might have been ill-advised, but it doesn't mean that it's a misunderstanding. And there is no reason for these totally disinterested eyewitnesses to testify to things that didn't happen. And they testified to very threatening, very incriminating statements that went along with this behavior. And the behavior itself, they testified that the fruit vendor ended up in the middle of the street. He was trying to back away, and this defendant. So this was absolutely the evidence supported the verdict.
Counsel, how do you respond to your friend's point that the judge erred in responding to jury note 3 by not reading the intoxication charge from the CJI as the charge appears in the CJI, that he deviated a little from the pattern charge?
Okay, the judge initially read the pattern charge in the final instructions. That's very short. The instruction that they were discussing after the note was while they were discussing the note was not from the CJI. It was from the McKinney's practice commentary to section 15.25, which really talks about the factors that go to when you're even going to give an intoxication charge. And it was clear from the discussion that there was a disagreement, that the defense counsel and the judge disagreed as to what the impact of intoxication could be. And the judge, in response to the jury's note, made the appropriate point that it has to be incapacitating to negate intent, and that impaired judgment is not enough. And I would note that in the McKinney's commentary, which the judge read, they referred to a case, People versus Gaines, which is a Court of Appeals case. And that case, this commentary says, the defendant's testimony that he had a couple of drinks and may have lost control, and the testimony of witnesses that the defendant was high and had glassy eyes was insufficient even to warrant a charge on intoxication. So what the judge said was completely consistent with People versus Gaines, and it was an entirely appropriate response to the no. The judge engaged in extended discussion with defense counsel and the prosecutor about how to respond. And the fact is that the position that defense counsel is articulating is just not legally supportable. The fact that you have impaired judgment because you're drunk does not negate a specific intent. It has to be more. It has to be incapacitating. That's what the judge appropriately communicated. We ask that the judgment be, if there are no other questions with respect to any of the other issues, we rest on our brief and ask that the judgment be affirmed. Thank you.
You may proceed.
Briefly, specifically with the witness, who was the cab driver and interpreter, Mr. Hasib, I believe his name is. He's the only one that testified that the golf club was raised above his head. Mr. Alam never said that Mr. Traylor raised the golf club over his head. He said that he was shaking the golf club and the bottle, saying yes or no. And Mr. Alam testified at some point that Mr. Traylor was 10 to 12 feet away, and then Mr. Traylor was 2 to 3 feet away. Never reached out to strike him, never, there was none of this, okay? And again, this goes back to the jury instruction, and it goes back to intoxication. It goes back to specific intent. It goes to, I really have to say that Judge Klott actually said that the intoxication has to be the point where there is, that the person cannot form intent. That's not, there's no support for that. And that eviscerated, any argument about intoxication and a misunderstanding. I mean, these things they're flexible to negate intent. okay? It's not that he can't, it's not that he has the inability to form intent. It's just, it's the jury's analyzing the facts as to whether the intoxication negated his specific intent to use those items in his hands unlawfully.
Thank you.
Oh, thank you very much.
Thank you so much. Fenton versus Hannah. Yes, of course.
Good afternoon.
Good afternoon.
My name is William Mate. I represent Mr. Fenton, who is the appellant in this matter. The court need only to look at the record on this appeal, which is contained in 6 volumes, 3,200 pages, to understand that this was not your simple run-of-the-mill guardianship proceeding that is usual in those cases. This proceeding was complicated by repeated efforts by Mr. Fenton's co-guardian to complicate the issues that he tried to...
By seeking documents that he was entitled to as co-guardian?
He had all the documents, Your Honor, okay? When Mr. Fenton filed his final accounting, everything was placed before the...
But he was entitled to them prior to the final accounting as a co-guardian.
And Mr. Fenton had the ability and did give him whatever he needed to address what he needed to address.
The question was whether he gave him what he asked for and was entitled to.
Eventually, all the documents were...
Eventually,
all the documents were provided.
But it sounds like from what your description of it makes it seem...
I'm sorry?
But you're suggesting that Mr. Fenton thought it was his role to act as the gatekeeper for what documents his co-guardian should get. Why was that an appropriate role for him to play? And wasn't a lot of the complication in this case the result of the failure to get along of the 2 guardians?
The 2 guardians did not get along from the inception, unfortunately. And that was premised, I believe, on the fact that James Hanna filed for a petition for his appointment as the guardian of the property of his sister. And that application was opposed by the court evaluator and the attorney for Kathleen, who all agreed that he should not participate as the guardian alone. And they objected to it, and they filed cross motions to it. And eventually, the parties reached a settlement. Mr. Fenton wasn't involved in any of this stuff. They came to Mr. Fenton because Mr. Fenton
but that
is a
dispute,
professional...
counsel, that dispute, for whatever reason, okay, did not change the fact that as co-guardian, her brother was entitled to certain documentation. Period.
And he had the availability to get all the financial records from the banks because he was a co-signatory on the bank, even though he claims that he wasn't and didn't open the account. In fact, that was a misrepresentation because indeed he did have the...
So I'm not going to give it to you because you could get it yourself, is basically what the co-guardian said to him?
Well, no, I don't believe it was that way, Your Honor. I think every time Mr. Fenton tried to do something for the estate, an obstacle was presented to him. Mr. Fenton did a tremendous amount of work in this case, as is indicated in the record. And if you recall, Justice Visitacion Lewis handled this particular guardianship.
Visitacion Lewis, good.
She handled this for 2.5 years until her retirement in 2018. It was only then that the lower court, Justice O'Neill Levy, took over the case. And in her decision, she doesn't address anything that occurred prior to that time. All she had before her at that time were 2 motions. One was a motion by Mr. Fenton to settle his final account, and Mr. Hanna's, James Hanna's motion to settle his abstract of final account. And those were the only 2 things that she looked at. And in fact, she didn't even look at or address any of the work that Mr. Fenton performed. All she did, in her opinion, and her opinion was a 13-page opinion, and there's only 1 paragraph that addresses the compensation issue regarding Mr. Fenton. And she says this was a short duration guardianship of 10 months, and this would be a windfall if his compensation was computed under SCPA 2307. She does not set forth anywhere in her opinion any elements that are required of her under the Potts case, under the Freeman case, under the Karp cases, all of which required her to set forth all of the elements and review exactly what Mr. Fenton had done up to that period of time. And she did none of those things.
Didn't
All
the
she
judge
did-
also characterize Mr. Fenton's conduct as quote-unquote troubling in her decision?
I think she said it was troubling. And yes, I believe some of the conduct may be a little bit troubling, but that was because he was being abused. There was an intention on the
Well,
part of the
there's an accusation of abuse on both sides here.
Yes, there are, Your Honor.
Yes.
And that's what has complicated, that's what complicated the proceeding. But that's notwithstanding that, there is nothing in the record, nothing in the judge's decision, which allowed her, even though she has discretion, to reduce the compensation, simply saying, well, I'm going to reduce it by $100,000 and not give an explanation except to rely upon the Goldstein versus Zabel case, which we have set forth in our case to show that they're distinguishable, those cases, and that she did not do anything to explain why she reduced it by $100,000, why she failed to grant Mr. Fenton his extraordinary fees, because she didn't even look at the record to figure out why he was making an application for those
I'm a
fees.
little troubled by your saying that the judge didn't look at the records. You don't know what the judge looked at, do you?
Well, she doesn't cite anything.
The fact that she chose not to cite them doesn't mean she didn't look at them, counsel.
Well,
I'm a little troubled, speaking of troubled, by your claim that the judge didn't look at the documents which you submitted.
Well, the only thing she,
Counsel, my colleague is still talking.
I'm sorry, Your Honor.
I mean, what basis do you have for your claim that the judge didn't look at the records, other than the fact that she didn't cite the pages that you thought she should cite?
Well, in her decision, at the outset of her decision, she says very, very clearly that the mental hygiene law guardianship here has a long and litigious history. And then she goes on and she cites to nothing other than the application by Mr. Fenton to settle his account and nothing further.
Thank you. You'll have time on rebuttal.
Thank you, Your Honor.
I'm going to give you 4 minutes since we went over.
It's very, very kind, Your Honors, but I think I could still maybe do it in 3.
Perfect.
But I'm going to try. Listen, my name is Robert Abrams. I'm for the respondent, Jeffrey Hanna, who is the nephew and the executor for Kathleen Hanna, who's now deceased. I mean, I feel like I'm in a bizarre reality here. First of all, Michael Fenton was an attorney fiduciary who should be held to the highest standards, an attorney fiduciary. In addition to this is a guardianship. It's about a family. James Hanna he's the brother of the incapacitated person. Jeffrey Hanna is a nephew. The reason why the court appointed a co-guardian, an attorney fiduciary, was so that they can help the family. The allegations against the family are just that. But even if some of these allegations were true, the reason why you appoint an attorney fiduciary is to have sensitivity to a brother who's watching his sister die. It was a 10-month guardianship, 10 months. There was nothing unusual. There was nothing out of the ordinary. I could go on and on, but...
Except for the degree of acrimony.
I'm sorry?
Except for the degree of acrimony.
There was a degree of acrimony, but again, if you read the paper, first of all, I'm going to address that, but before I even address that, the idea that my friend here can say that the judge didn't review the record, the first 7 pages of the decision is everything that she did and everything that she based the decision on. The acrimony issue is obviously something that the court noted in her decision, but the court basically said that she expected the attorney fiduciary to be able to rise above that. I believe that Ms. Sullivan, who represents James Hanna, will address some of the things that Mr. Fenton did, so I won't do it here. What I would like to do in my remaining time, just point out to the court that in Goldstein v. Zabel, which I believe Justice Genzer actually sat on that bench, the court made 3 major findings that are applicable here. In the first instance, in that case, the attorney guardian requested a fee for $700,000.
the court reduced it to $100,000 and basically said that the court has the power and authority to do that under 8128B of the mental hygiene law, where the court, under any respect, for any reason, if the court feels that the guardian has acted inappropriately or has done something that's wrong, they can adjust the fee as they see fit. That's the discretion that the trial court had, and she exercised that discretion. The last thing is, the judge pointed out in her decision the misbehavior, the unethical behavior of Michael Fenton, and she had every right to take that into consideration, which is pointed out in Goldstein v. Zabel, where in that case, the court decided that that guardian did not act inappropriately. In this case, Mr. Fenton did act inappropriately and didn't act unethical. And I also point the court to its decision in matter of Leventhal, again, which is in our papers. The court basically defines extraordinary, you don't get extraordinary fees for doing ordinary tasks and ordinary behavior. That comes under your fee. And the court also pointed out about attorney's fees, that the court has the absolute right to decide whether or not attorney fees should be awarded and whether or not the work that the attorneys did had a positive impact on the guardianship. In this case, the court clearly determined that the attorneys for Mr. Fenton did not have a positive impact for the guardianship. I basically said that I would keep it within 3 minutes, Your Honors, and I've tried.
You're on 24 seconds left, so good job.
So I would like to say in my last 24 seconds, thank you.
Thank you. All right, counsel, you're up next.
Thank you, Your Honors. May it please the court, Lori Sullivan for co-guardian James Hanna. You're right, Your Honors. There was a lot of acrimony here, but it was acrimony that Mr. Fenton directed at everyone in this case. The court examiner, and I apologize for my language, Your Honor, he told him, you know where you can stick that. Ms. Canzaneri, in a deposition, he told her, you're just breaking my balls. He called Mr. Hanna an arrogant prick. He said he was like tits on a bull, useless. And it went on and on and on. And he created this false narrative that Mr. Hanna was only interested in Kathleen's money. And what's a unique situation here, Your Honors, is that we have his own words documented in emails, but we also have Kathleen's words through Michael Massetti, her court-appointed attorney, who said that Kathleen was very appreciative for the help that her brother Jim and his family had given her, and that she loved him very much. She found him to be a devoted brother. So we're fortunate enough to have those words. Also, Your Honors, there was a voluminous record before the court. There were hundreds of emails, Mr. Fenton's own words, and all of the applications that were before the court. Mr. Massetti's words. Now, Mr. Fenton did say about Mr. Massetti, I take what he says with a grain of salt, as much salt as in the Department of Sanitation. He spared no one with the acrimony. The applications that Mr. Fenton brought were of no value to the guardianship. One was to object to Mr. Hanna seeing Kathleen's will, and Kathleen told Mr. Massetti she wanted her brother to see the will, yet Mr. Fenton opposed that. One was to the clean out of the apartment. Kathleen told Mr. Massetti, I want the two of them to clean it out together. Mr. Fenton didn't listen. He cleaned it out on his own. Mr. Fenton brought an application to increase the compensation of Valerie Paulino. Kathleen told Mr. Massetti she didn't want the compensation altered. He did all of these things that were contrary to Kathleen's wishes and provided no benefit to the guardianship. The judge also had his time records before her, and his time records included work for secretarial and travel time. But most troubling is that his invoice showed a date of May 2nd, 2019, and when you looked at the services, he was billing for dates in the future. So the judge had a voluminous record before her. She set out in many pages all of the documents she reviewed. And I would like to point out two things. In my friend's main brief on page 7, he said that two of the applications were standard in guardianships, therefore not extraordinary. And on page 24, he says the issue of fees is a judgment call. Well, I submit that Justice O'Neill Levy made the right judgment call. Thank you, Your Honors.
Thank you.
Let me just address some of the issues that were just approached. Mr. Fenton marshaled $6.5 million worth of assets in this estate, and there's no suggestion that he did anything to compromise the IP, Kathleen Hanna, in any way, or that he imposed his will or anything upon Kathleen Hanna. In fact, despite what the counsel has said, the record reflects that the will opening was requested by them, and it was Kathleen who said she did not want the will open. That raises issues of fact, and many issues of fact should have been addressed at a hearing in this case where Mr. Fenton could have had the opportunity to present and cross-examine many of the innuendos, many of the accusations brought against him. This became an adversarial proceeding, unfortunately, between the two guardians. And as a result, it became much more complex than it should have been. And at the end
Do you dispute Ms. Sullivan's description of some of the statements made by your client?
I believe some of those statements were made during the course of a deposition.
And do you think those are appropriate statements in a deposition?
I'm not sure they're appropriate, Honor, and I don't condone
You're not
them,
sure?
But
Counsel, stop. Stop, stop, stop. The statements she made here, if they were made, there's no question that they are not proper. And your unwillingness to acknowledge that is troublesome.
Well, in the context of a deposition where he is being interrogated as though he's a criminal and has stolen.
Under no circumstances,
And they are...
counsel, under no circumstances,
Under some...
are those statements appropriate for an attorney counsel at law?
Your Honor, he is an attorney at law, and he is acting in his position as a guardian, but he is still a human being. And as a human being...
So am I.
And when he gets attacked on innuendos and false accusations and other things like that, he obviously reached the point and made a couple of comments that were not that profane. They were not that profane.
I'm glad you think so. Thank you.
Thank you, Judge.